Recognition of states in international law. International community is a living entity in the sense that it is changeable. The identity and number of states are by no means fixed and invariable. History produces many changes. Old states disappear or unite with other states to form a new state, or disintegrate and split into several new states. Even in the case of existing state, a revolution or unconstitutional event may occur and the status of new government becomes a matter of concern to other states, which formerly had relations with the displaced government. These instances raise several problems for the international community. The most important problem is the question of recognition of the new state or the new government. Each state has to decide whether to recognize the new state or the new government. Recognition involves legal consequences both internally and internationally. If an entity is recognized as a state, it will be entitled to rights and subjected to duties that would not be relevant otherwise, and it will enjoy privileges and immunities of a foreign state before the national courts, which would not be allowed to other entities. Definition and nature of recognition. Recognition is a discretionary unilateral act exercised by the government of a state officially acknowledging the existence of another state or government or belligerency. It is one of the most difficult subjects of international law. It is a complicating mixture of politics and laws, both national and international. It is difficult mainly for the following three reasons. Recognition is, as the practice of states shows, much more a question of politics than of law. The act of the recognizing state is conditioned principally by the necessity of protecting its own national interests, which lie in maintaining proper relations with the new state or the new government. In form and in substance, recognition remains primarily a unilateral diplomatic act on the part of the recognizing state. There are several distinct categories of recognition: a sense the recognition of a new state, a new government, and belligerency a sense de jure, de facto, conditional, implied and express recognition. Basically, there are two theories as to the nature, functions and effects of recognition: the constitutive theory and the declaratory theory. The constitutive theory considers that the act of recognition by other states creates a new state and grants it the international legal personality. This implies that the new state is established as an international person by virtue of the will and consent of already existing states. In case of a new government, it is the recognition that grants it the status at the international level. The constitutive theory is opposed by the declaratory theory. According to the declaratory theory, recognition has no legal effect. Statehood or the status of a new government exists as such prior to and independently of recognition. The existence of a state or a new government is a question of pure fact. The act of recognition is merely a formal acknowledgement of established facts. When an entity satisfies the requirements of a state objectively, it is a state with all international rights and duties, and other states must treat it as such. Article 3 of the Montevideo Convention on the Rights and Duties of States of 1933 provides that the political existence of the state is independent of recognition by the other states. Even before recognition, the state has the right to defend its integrity and independence. Recognition of a state and of a government. When a new state comes into existence, other states are confronted with the question whether or not to recognize it. Recognition implies a willingness of the recognizing state to deal with the new state as a member of the international community. To grant recognition to a new entity, the entity must satisfy the basic requirements of statehood. Recognition of a state defines its membership in the world community, and consequently supports its claim as an international person. It allows the recognized state to exercise the rights and duties of a state under international law. Recognition of a new state automatically involves recognition of its government, although the latter may be recognized only de facto. Recognition of a new government is quite different from the recognition of a new state, although in principle most of the considerations whether legal or political apply equally to both types of recognition. As far as a state is concerned, the satisfaction of basic requirements of statehood is examined by the recognizing state before granting its recognition to the new state. Recognition of a new government requires its satisfaction of certain conditions such as effectiveness and independence. The existence of an effective and independent government is the essence of statehood. By recognizing a government, the recognizing state accepts to deal with this government as the governing authority of the state and grant it the legal consequences of such status in terms of privileges and immunities within its domestic legal system.